Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
So let's start. We're going to start in San Francisco. And this is the issue noted on your blog as San Francisco firefighters are fired over COVID-19 vaccine mandate. God, I can't talk today. And the topic is, it's funny because these are things that were already litigated way back. So seeing it now, it's almost kind of, enough already. But so here, 21 San Francisco firefighters were fired for failing to comply with the city's vaccine mandate. And I just want to note, right? So they were fired. Do we know the dates they were fired? Because I have all these issues which are kind of interesting today.
I don't, but my sense is they're in the complaint. I mean, it's a lengthy complaint. I'm looking at it's 179 pages. I know that's not all the complaint. There's some attachments and some different things in there. So I'm sure it's in there, but I agree with you. It's interesting in that now time has gone by. Our perceptions of it have changed, and we'll see maybe if the courts are going to look at it a little bit differently as well. I think that's going to be something to consider.
And let me explain the facts, and then I'll explain. You and I are going to be on the same page. But so they want reinstatement. They claimed that they were discriminated against based on religious bases. And they claim that the city failed to accommodate them under their religious beliefs. Now, I got to tell you, I don't know a lot about San Francisco, but it's a pretty liberal city. So, except, look, I don't want to get controversial. A lot of people say, well, so liberal, but you're mandating a violation of rights by, vaccine mandates. I won't go there, but liberal has a new meaning today. I just don't know what it is. In any event, what the complaint alleges is that they all had sincere religious beliefs. And I don't think there's a question that they didn't really have these religious beliefs. And they provided convincing evidence that they held these beliefs. But according to the city, they had no way to accommodate their religious beliefs. Now, that's where I want to come back to today, because today versus a year ago, maybe different knowledge, right? And I'm going to pick on the government because I can, but we'll get back to that in a second. So they said that, the CDC's understanding of whether or not the COVID vaccine had limited limited effectiveness, or whether it diminished the transmissibility, right? They were still trying to figure out the vaccine's effectiveness. But so they said, well, it's speculative. So they claim that the defendants discriminated against them and took adverse employment action based on their good faith beliefs. And there have been a number of these suits. But the dates, to me, is where we are in our understanding of COVID and the vaccines. That's what I think is important. In any event, they claim that the city violated the religious constitutional rights, even while imposing the least, right? It's kind of double negative, but the least narrowly tailored and most restrictive rules and requirements based on the COVID vaccine policies, et cetera. So they were fired. They want reinstatement. Here's the interesting thing. So let's go back to this. So the question is about an accommodation, and I am never going to get away from it. Why is it not acceptable to wear a mask and have that not be an accommodation? Because if you replay the 10,000 times that Fauci and everybody else are on the news saying, well, masks, double masks, 100 masks, I don't care, put however many masks you want, put a Darth Vader mask on if you want. The masks are supposed to prevent the spread and the transmission both ways of, right? And especially in N95. So why is that a reasonable accommodation? Why are we going to the
They also make a P100. So you could tell them you got to wear P100.
I don't care if they wear SCBA. I mean, why is there no accommodation? And why is vaccine the only accommodation? So I think it will be very interesting, for a court to look at this issue now versus a year ago versus 2 years ago. Haven't we seen the vaccines now have limited effectiveness, new variants? And I'm vaccinated. This isn't a political issue.
I am too.
But But
Well,
how are masks not better than the vaccine?
you know, I look at it, and as attorneys, they drill this into our heads, starting the first day of law school, that you craft the issue so that it's answered in a way that's going to support where you want to get to. Okay. And the firefighters are going to argue that should I, based on my circumstances, should I have the right not to get the vaccine, whether it's religion or race or whatever other parameter may be, my particular health condition, my disability, all those things. Should I be required, okay, to undergo this sort of experimental kind of vaccine, which I think we're beyond that now, but should I be required to, or does our Constitution, do all the laws protect me in this situation? So that's sort of the question the firefighters are asking, okay? From the employer is saying, don't I have a right to require my employees to do this in order to protect them? And depending on which question is really the more, because they're going to go to court, and the firefighter is going to argue their question, the employer is going to argue their question. The court then has to say which one of those two questions is the real question.
But the least, the standard is there a lesser invasive option, right? Which could be accommodated.
Well, not if the question is, does the employer have a right to impose something that the federal government has said that everyone ought to be doing? So I think, and fine, this is COVID. We're at a certain point now where we've managed the fatalities and some of the bad outcomes and everything. We weren't there 2 years ago. And so the rulings here may have legs in a different context, such as Ebola or a fatal disease. And it's the same principle. If the employer has the ability, when the federal government, the CDC, WHO, and everyone else says, we need to be vaccinating everyone, and we're sending you to these kinds of emergencies where you're going to be exposed to Ebola or whatever else is coming down the pike. And as an employer, you have the right to require this of your employees. If that's the question the court sees, then I think there's only one way that they can answer it. And they answer it the same way they did in the 1800s and early 1900s when it came to smallpox and polio and a lot of other things. So on the other hand, if it's viewed from the firefighters' perspective and their question is going to predominate, then we get to those other issues. So who knows, and I can see two judges, depending on their, perspective, going in different directions on it.
I still get, I'm guessing you don't agree, but I still get to the question of on either issue, is there a least, is there another option that's less burdensome on the employee? And to me, in all other cases, right, with reasonable accommodations or lesser invasives, or there's always the question of is there another reasonable option to accommodate these individuals? And how do we not say a mask is better than the vaccine today?
Well, that's my point is, do we even want to get, will the court even entertain a discussion on how effective the vaccine is versus how effective the mask is? Or will the court just say, look, the CDC said it, the employer had a reasonable basis for doing this, and that's as far as we're going to go? Because up to this point, most of the courts seem to have been going in that direction.
Yeah, and I don't disagree. If I was the judge, and I can't be, apparently, I must have finished too high on the law school.
Don't get into it. We're gonna we'll get ourselves sanctioned by a court. We
Sorry for any judges that are watching in their spare time. So, but if I'm the judge, what I'm saying, I am looking at what is the goal you're trying to achieve, what is the method of getting there, and is the way you're getting there, again, is there a less burdensome option to achieve your goals? And and when it's a balancing of interest tests, you look at the employer's need, which is protect his employees, protect other employees, protect the public.
Yeah.
Okay, and then you look at the employee's rights, right? Whether it's disability or emotional or religious in this case. And then the problem is you can get there both ways by wearing a mask. And how can any fire department or ambulance service today say, well, wearing a mask isn't viable? That's what we did for 2 to 3 years. So I have a hard, especially now based on new research, when it's clear that the effectiveness wanes. This is also a continuing burden, right? To say you have to continually get vaccinated with every new, new thing that comes out. So the employer now would be in the position of saying, now you need a booster, you need another booster. And here's my, this is where I always would have argued it. I never saw this argument during COVID, but here's my argument. Flu vaccine, not mandatory. Hepatitis vaccine, not mandatory. You can get a waiver.
Well,
right?
Really? For hepatitis B? Really?
I
thought that was mandated.
Right, the hepatitis, you only have to offer it and you can get a declination, but it's not mandatory. HIV has vaccines. Why isn't that mandatory, right? So there's all of these things. Bloodborne pathogens, what do we still say? Wear gloves and a mask, right? Tuberculosis, TB, we offer the tests, but I think we're taking irreconcilable different approaches to the flu, which is just as bad as COVID, to the to hepatitis, which could be just as bad, although not as transmissible, but maybe in the ambulance, right? So why aren't we taking the same approach? Prophylactics through use of gloves and masks stop the transmission. I think the approach to mandating a vaccine is incomprehensible.
And I think your argument makes a lot more sense today than it did 2 years ago.